Hello viewers, welcome to my channel. I'm Hasham. So last video I have started the new topic discharge of contract. If you have watched that video, definitely you can be able to know the meaning of the term discharge of contract and what are the modes through which a contract is discharged. So this video is the continuation of the last video. In this video I am going to explain you two more topics on discharge of contract and some practical problems I am going to discuss about the discharge of contract in this video. So watch the video till the end. If you have not watched the earlier video, you cannot be able to understand this. So I suggest you go to the playlist of my channel, select the subject business law, select the topic discharge of contract. Watch the first video, you can be able to know the meaning of the term discharge of contract. Discharge of contract means a time when the obligations of the contract are completed. The contractual relationship between the parties comes to an end. That means the obligations will expire, will cease. So a situation when the contractual relationship comes to an end, that is called discharge of contract. And there are 6 modes of discharge of contract. Already I have discussed in detail in the last video. Now 2 more topics I am going to discuss in this time, in this video now. The first, law relating to supervening impossibility. Impossibility of performance. This is also one of the mode of discharge of contract. When the contract cannot be performed, when the obligations cannot be performed, impossible of performance, then the contract will be discharged. So supervening impossibility means the impossibility arising after the formation of the contract. So first of all, I explain you when the contract will be discharged on the impossibility of performance. If the agreement involves a term which are impossible to perform, if in a contract, if in an agreement there is a term which is impossible to be performed, then the contract will be void ab initio, because before the formation of the contract itself there is a term in the contract and that a term is completely impossible to perform. So from the beginning itself the contract will be void if the contract contains a terms which is impossible to perform. An agreement to do an act impossible in itself is completely void. Now, the impossibility which develops after the formation of the contract is termed as post-contractual or supervening impossibility. The next type of impossibility is the impossibility arising after the contract had been undertaken. After the formation of the contract, some impossibility arises. So impossibility arising after the formation of the contract is called supervening impossibility or post-contractual impossibility. Now what will happen if there is a post-contractual impossibility? Now I am going to explain you the law. A contract is discharged by supervening impossibility in the following conditions. The 5 conditions are given. In these 5 conditions, the contract will be discharged. The obligations will come to an end if there is a supervening impossibility or post-contractual impossibility. So what are the situations under which the contract will be discharged? First one, destruction of subject matter of a contract. If the subject matter of the contract was destroyed, destruction of subject matter of contract. That means after entering into a contract, the subject matter of the contract was destroyed. Automatically it will be discharged. The contract, the obligations will be over, will be finished. Example, A enters into a contract with B. A says, will you purchase my horse for rupees 10,000? B says, okay, I will purchase your horse for rupees 10,000. Agreement take place. But unknown to both the parties, after entering into the contract, the horse died. At the time of entering into contract, the horse was alive. The horse was alive at the time when A enters into contract with B. After entering into contract, before the completion of the contract, before the obligations are completed, the horse died. That means the subject matter of the contract was destroyed. Now automatically the contract is discharged. The obligations of both the parties comes to an end. This is the supervening impossibility. Next one, non-existence of a specific state of thing. When a contract is made, it is based on some state of thing. Some conditions are there. Some condition. So when contract is made, it is made on the basis of some condition. But later on that condition was changed. That condition was not existing. Then automatically the contract is discharged. The contract is discharged. Next one is third, death or incapacity of personal service. Death of a party or incapacity of a party will also discharge the contract. Example, A enters into contract with B. Suppose A proposes to B. A proposes for marriage to B. Then all of a sudden B expired. Then automatically the contract comes to an end. Discharge of contract, because one of the party to the contract expired. Or incapacitated. Incapacitated means it is not up to the mark. It is not up to the mark. For example, A proposes B to marry, but all of a sudden B was found that she is having some disease or she met with an accident. Then A says, no, I don't want to marry B because she is incapacitated. So in this case also the contract is discharged due to the death or incapacity of the person. Then change in law. Sometimes the law also changed. When we make the contract, there is a lawful activity, but later on account of change in the law, that activity has become unlawful. Then automatically the contract will be discharged, because there is change in the law due to which it is impossible to perform the contract. Due to the change in the law, it is impossible to perform the contract. So the obligations will come to an end. Next comes outbreak of one. If a contract takes place during the war period, then it is completely unlawful. It is void because it is unlawful. At the time of war, a contract has been entered with the enemy nation. Then the contract will be void. Suppose a contract is already undertaken, after formation of contract there is a war. War broke out. In that case, what will happen? The contract will be unlawful, will be suspended during the period of war. Then after the war period, the contract will revive again. So temporarily it will be suspended during the period of war. After war, it will revive. So these are the cases where a contract is discharged by the supervening impossibility. Supervening impossibility. That means impossibility arises after the formation of the contract. In examination, a theory question will be asked in examination regarding explain the law relating to supervening impossibility. So you have to write this explanation which I have given just now. Supervening impossibility. Now there are some exceptions to the law of supervening impossibility. Exceptions to the law of supervening impossibility. That means a party will try to make excuse that on account of supervening impossibility the contract is discharged, but the law says the contract will not discharge. The obligations will remain same in spite there is a supervening impossibility. So even if there is a supervening impossibility, the contract will not be affected. The contract will remain same. The contract will not be discharged. So here these are the exceptions to this rule. These are the cases where the contract will be discharged due to supervening impossibility. And these are the cases where the contract will not be discharged. The contract will remain same in spite of supervening impossibility. What are the cases? Impossibility of performance is not an excuse for non-performance of contract. So what are the cases? First one, difficulty in performance. If the performance has not become impossible, but it is difficult, so in that case, the contract is not discharged. For discharging the contract, the performance should be completely impossible. If the performance is not impossible, but it is difficult to undertake, then the law says the contract will not be discharged. The parties will be in the same position as they were before. The obligations will not be affected due to the difficulty in performance. Simple example. A contract is made between A and B. A says, I will supply the goods to you at rupees 100 per unit. But all of a sudden, due to inflation or due to government policy, the prices have increased suddenly. Now A says, I will not supply the goods to you because the prices have increased in the market. How can I be able to supply the goods? I have agreed to supply at 100 rupees, but right now prices have increased in the market. I will not supply. It will be difficult for me. The law says, no, you cannot escape from this obligation. You have to supply. It is difficult, but not impossible to perform the contract. So difficulty in performance. If there is difficulty in performance, the contract will not be discharged. The parties should be in the same position. Commercial hardship. Sometimes it will be difficult to perform the contract because there is difficulty in the business operations. In the business operations, it will be difficult to perform the contract. In that case also, the law says the obligations will not be completed, the contract will not be discharged. So these hardships in the commercial activity will take place. That is not a completely impossible thing. The contract can be performed even during hardships. Next one, impossibility due to the conduct of a third party. Suppose the contract between two parties is dependent on the performance of a third party. The contract between two parties depends on the performance of a third party. If the third party makes some failure in the performance, the original contract will not get affected. Example, A enters into a contract with B to construct a building. The construction of building is the subject matter between A and B. So A promises to B that I will construct your building, and the agreement is over. But A has given a subcontract to an electrician, but electrician has not performed the activity. Now, is the obligation between A and B get affected due to non-performance of the electrician? Law says no. Due to the non-performance of the third party, the obligation between the original parties will not be discharged. The obligation remains same. Next comes strike, lockout and civil disturbances. These strike, lockout and civil disturbances will not discharge the obligations of the contract. Even if these things happen, the original contract will remain same. We cannot excuse that it is impossible to complete the contract because of strike, because of lockout, because of civil disturbance. So these things will not affect the discharge of the contract. The obligations will remain same. Last one, failure of one of the several objects. If in the contract there are number of objectives given, if one or two objectives are not fulfilled, then automatically the contract will not be complete, will not be terminated, will not be discharged. So if so many objectives are given, so many terms are given, if there is one or two terms are not fulfilled, then the contract will not be affected. The obligations will remain same. So these are the exceptions to the rule that supervening impossibility will not discharge the contract. Will not discharge the contract in these cases. So in examination, you may get 3 questions from this discharge of contract. First question, what is discharge of contract? What are the modes of discharge of contract? Already I have explained you in the last video. Second question, what is the law relating to supervening impossibility? If the impossibility happens after the formation of the contract, what will happen when the contract will be discharged? These are the cases. Next one, exceptions to the law relating to supervening impossibility. If there is supervening impossibility, when the obligations will remain same, when the contract will not be terminated, even there is supervening impossibility. So what are the exceptions? So here I have explained the exceptions. That's all. This is the end of the topic discharge of contract. Now I am going to start few problems on discharge of contract. So before starting these problems, I suggest you to take a printout of the problems which are given in the link under my description. So take a printout, keep it ready and watch this video. Now first problem I am reading out. The unloading of a ship. The unloading of a ship was delayed beyond the date agreed with the ship owners owing to a strike of dock laborers. The unloading was delayed due to strike of the labor strike was being there, that's why unloading was delayed. Now on a suit by the ship owners for damages, the plea of impossibility of performance was raised. Advise the ship owners. See, a court case has been put that unnecessary delay was made in unloading the material from the ship because there was a strike of the laborers. The case was before the court of law. The court says the strike, the delay due to strike is not a supervening impossibility. It is difficult but not impossible. On account of strike, they cannot plead that on account of strike this delay is impossible. No, it is possible because the strike is a situation where it can be avoided or alternative action can be taken. So this strike is not an event which is completely impossible. So the ship owners can claim damages. The ship owners can claim damages. Second one, a wine merchant contract to sell to a customer 5 dozen bottles of a particular brand of champagne. At the time of the contract, the wine merchant's whole stock of wine had been destroyed by fire, but he was not aware of the fact. What is the effect on the legal rights of the parties? The legal rights of the parties will not be affected because the event is not completely impossible. The shop owner has entered into a contract with the customer to supply 5 bottles of champagne. All of a sudden, there was a fire in the wine shop and the complete wine was destroyed. Now the event is not completely impossible. It is possible. It is difficult but possible. The shop owner can procure the bottles from somewhere else and he can supply it to the customer. So the law says the event is not completely impossible, it is difficult. So the rights and obligations of the parties will not be affected. The contract will not be discharged. Third, an existing mortgage was discharged by the substitution of a new agreement of mortgage. This is called novation. New contract, novation. That means a contract is discharged by agreement or consent. Under agreement and consent, a novation, a new contract can take place, replacing the old contract. An existing mortgage was discharged by the substitution of a new agreement of mortgage. The new agreement could not be registered and hence it was not enforceable. Could parties fall back upon the original contract? Yes, of course. A new contract is made, cancelling the old one. But the new contract was not completed because of registration. Because of registration, the new contract cannot be able to apply. In that case, the law says the parties can go back to the original contract. The original contract will remain intact. Now, fourth point. An artist undertook to perform a concert for a certain price. An artist undertook to perform a concert at a certain price. Before she could do so, she was taken seriously ill. Is the contract discharged? Yes. Just now I told you in this supervening impossibility when the contract is discharged. Death or incapacity of personal service. Death or incapacity. Here the artist is seriously ill. She is incapacitated to perform. In that case, the contract will be discharged. So in this case, the artist undertook to perform at the concert, but on account of serious illnesses, you cannot be able to perform. So contract is discharged. The obligations will come to an end. Fifth point. C. Let a music hall to T. C. Let out a music hall to T for a series of concerts on certain days. The hall was accidentally burnt before the date of the concert. Is the contract discharged? Yes. The subject matter of the contract is the hall, and the hall was completely destroyed before actual date of consent. Then the subject matter is destroyed. Here you can say destruction of subject matter of the contract will make a contract to come to an end. Discharge the contract. There is no obligation. Now, sixth point. A owes rupees 5,000 to B. And A has to pay to B 5,000. He pays 2,000 to B. And B accepts the amount in satisfaction of the whole amount. Is the debt discharged? Yes, the debt is discharged. Already in the last video, I have explained you regarding remission. Remission means when part payment, not full payment, when part payment is made by one party to another party in full settlement of the account. In full settlement of the account, in that case, the contract will be discharged. Here 5,000 rupees is the debt amount, but only 2,000 rupees are paid in satisfaction of the claim. That means the contract comes to an end, discharged. Seventh, an artist undertook to paint a picture for a certain price. Before he could do so, he met with an accident and lost his eyesight. Is the artist discharged from performing the contract? Give reasons. Yes, of course. The contract is discharged because the artist is incapacitated. The artist's eye was lost. So when the eye is lost, the artist cannot be able to perform his obligation. The contract is completely discharged due to supervening impossibility. 8th point. A due to B rupees 5,000. A due to B rupees 5,000. C, a friend of A, pays 2,000 to B and B agreed that the amount in full settlement of the amount due to A. Discuss whether A is relieved from the responsibility. Yes, A is relieved from the responsibility. A has to pay 5,000. But C, the friend of A, has paid 2,000. And B says, okay, by paying 2,000, your obligation is completed. That means when the consideration is moving from the promisee or any other person, if the consideration has moved from any other person also, the contract is completed. Here, A is relieved from his responsibility. 9th point. A and B agree to marry each other. Before the time fixed for marriage, A goes mad. Is the contract valid? No, contract has become void. When one of the party has become mad, A and B agree to marry. But before marriage, A goes mad. So the contract will become void. It is impossible to perform the marriage with a mad person. So the contract becomes void. It is not valid. Last one. There was an agreement between D and P to repair certain machinery. Agreement to repair the machinery between D and P. D failed to repair the machinery due to strike of the workmen. Due to strike of the workmen, D cannot be able to repair the machine. Is D discharged from his obligation? No, he is not discharged from his obligation. Due to strike, the performance has not become impossible, it has become difficult. The performance due to strike has not become impossible, it is difficult. So law says if the performance is difficult, the contract will not be discharged. The obligation of the parties remains same. That's it. So these are the 10 practical problems I have explained you. So this topic of discharge of contract is completed. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance their knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, we'll take up the next topic in the next video.